Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. What is up next in the Idaho versus Kohberger case? What are the attorneys probably working on right now on both sides? Well, it goes without saying, if you've been following the case, that Judge Stephen Hippler will be entering rulings on all of the motions that he entertained on January 23rd and 24th. These are the multiple motions to suppress and also the request for a Franks hearing. So we're waiting for those rulings. Whichever way the court leans could change the course and scope of the rest of the proceedings in favor of the state if those motions are denied in favor of the defense, if any of the motions are granted. In returning to the redacted order governing further criminal proceedings and notice of trial setting, this was filed on October 9th, 2024. I like to refer to it as the pretrial and trial order. We can review what the court has set as deadlines for current and upcoming matters. If you go to page 2 of this filing, you will see some very familiar items. You'll see under Section B motions, the DP motions, they have been totally resolved. All briefings were in. The court made rulings denying all of the defense's motions to strike the DP. The discovery motions, those are also resolved to the extent that the only thing that's remaining is the entry of an order, although the court did make some verbal proclamations from the bench as to what he expected regarding the single discovery motion that was before him dealing with expert witness disclosures. We're just waiting for a written order to come down. The next section, these are the Rule 12 ICR motions, and this is all of the motions to suppress that the court entertained. We are waiting for rulings on them. Next, the motions in limine. We did a presentation recently on what motions in limine are. They are coming up due February 10th, 2025, with responses March 3rd, 2025, replies March 17th, 2025. This, by the way, is what the court references when he talks about briefings. For instance, the defense filed a motion and there were briefings seeking to open up to the public, both the hearing and the briefings regarding their motion to suppress IgG DNA evidence. Motion, response, reply, those are the briefings. The hearing on these upcoming motions in limine, just like what we saw with the motions to suppress, the court has actually set aside 2 days of his time. April 3rd at 9 a.m. is when these motions in limine will be set for hearing and continue on to the following morning at 9 if necessary on the 4th. Then, if we go down into the next section, experts. A list of experts the parties intend to call at trial. These are trial experts, not experts for any hearings, including a copy of the expert's report, consistent with ICR 16b7, that's the rule of court in Idaho governing expert witness disclosures, and a copy of the expert's curriculum vitae. This is also known as a resume. Shall be disclosed to the opposing party as follows. State's guilt phase, this came and went. This was December 18th, 2024. Same with the defense's guilt phase experts, January 23rd, 2025. All of the expert witnesses that have been disclosed thus far are under seal. That means the names, the reports have been filed under seal by both sides, with the caveat being there was some information disclosed by the state in support of their opposition to the defense's motion to compel and motion for sanctions regarding what they felt were inappropriate or incomplete expert disclosures. So the next part that I want you to look at is if you go to the next page, because the section of expert disclosures for trial continues. We see here that the rebuttal guilt phase experts, this is the state's experts rebutting to any disclosures that the defense made. So in other words, you saw on the prior page, there was a date that the state was required to turn over their expert witness disclosure for the guilt phase. And then the defense's expert witnesses for the guilt phase. The state, because it is their burden of proof at trial to prove every element of every crime that Mr. Kohberger was charged with via indictment by the grand jury back in May 2023. There are 5 first-degree felony counts. The state bears the burden of proving each and every element of each and every crime he has been charged with. They get to have rebuttal experts, rebuttal guilt phase experts. Those are due February 13th, 2025. I like to call guilt phase the case in chief. This is the part of the proceeding, again, where the state of Idaho bears the burden at beyond a reasonable doubt evidentiary standard of proving their case to the jury. The next section are the penalty phase experts. This is if and only if there is a conviction, and Mr. Kohberger is, of course, at all times considered innocent under the eyes of the law until or unless there is some sort of a plea by him, or if he is adjudicated guilty at trial. If he is adjudicated guilty at trial, then it goes into the penalty phase experts. Those are due January 27th, 2025, where the issue of what should the penalty be in the event of a conviction. Then there's, as with the case in chief, the defense gets to name their penalty phase experts March 31st, 2025, and then the state with rebuttal penalty phase experts April 28th, 2025. And then if we go down to trial materials, we see that the proposed jury questionnaires that will be administered to the potential jurors in this case to try to seat a jury shall be simultaneously filed under seal. The court has already stated that this is to be under seal and off the public docket per this order, March 24th, 2025, with objections by both sides to the other side's proposed jury questionnaire questions due March 31st, and then a sealed closed hearing on the matter will be held on April 16th, 2025. And then the next section are not due until the month of April as we head toward the voir dire of this matter, which per page 1 of the court order of October 9th will occur on July 30th, 2025. That is the process of attempting to select the jury panel members and all alternates. If you look at page 1 of this order, you will see that voir dire is July 30th, 2025. I believe that this is the official start of the trial because, number one, this is a jury trial. It is not a trial by bench. It is not a trial that Judge Hippler will sit as trier of fact and determine if the case has met its high evidentiary standard or not. This is by a jury, and a jury trial cannot commence without the process of selecting a jury panel with alternatives. This will now conclude this episode of the Indie Zone. If you have any questions, comments, please leave them here. All feedback is appreciated. And if you like our contents, please do subscribe to the channel. It helps us out a lot. Thanks for joining us here today.